Now that I've done all this searching, what I want to do is I want to get a little bit more precise in the classification that I'm searching and a little less precise in the exact words that I use. The Patent Office uses various classification systems, basically an indexing system into which every type of invention that's been filed gets classified. And we can go in and we can actually search these classifications by themselves with or without other words. That will get us into the right categories, perhaps, for different types of inventions without being restricted to the specific words that we think should be used. Because you'll often find that what another inventor has used to describe their invention isn't the same wording that you would use, even though the invention might be quite similar. So we're going to look now at how to identify the classifications you want to search and go in and run those searches on the classification systems and see if we can find any more relevant results, and perhaps maybe more specific and close results to what our own invention is. So I've got two cases that I've still got open up here, and I want to look at these. We've already copied off the information. What I want to look at next, though, is I want to look at the classifications that are right below the information we copied before. So current class, US class, the CPC class, and the international class. Those are all different classification systems that are used. You can use one of them, you can search all of them. They'll be very similar, but they're not identical. So I would usually just pick one, either the US or the CPC, but it really doesn't matter. You can pick whichever one you want to use to do some additional searching. So we can see here that the US class is in class 211, subclasses 70.6, 65, 87.01. There's also class D6 with subclass 553. We can go look at what the classifications say and then see if those are the ones that would be relevant for what we're doing. So we'll do that in just a minute. But before we go there, I want to go over to this other one and see if the classifications are different. So here, this was, if you remember right, this was our kind of golf club cart implementation for tool storage. And they used class 280. It may be because it's a wheeled device instead of a device that's screwed onto or fastened to a wall. That might make a difference in the way that it's classified. So we'll just need to go look at those classifications briefly and see what they say. In order to get to the classifications, I want to go back to the main page, and just to make it easy and show you another way to find these things, let's look up classifications in the search bar at the top here. So this page gives us a little explanation about how classifications are used. It tells us what the different classification systems are. The CPC is the Cooperative Patent Classification. USPC is the US classification system. So we can look at each of those and determine which one we want to use. I'm just going to stick with the US classification for now because I don't think it'll make a big difference in the end which one that we go with. So as I drop down this menu for the US classification system, you can see a lot of tools and resources here. This is great. Like a lot of things on the US Patent and Trademark Office website, they have a lot of information. The trouble with the information they provide, sometimes it's not the most efficient way to get through the process. Sometimes it's confusing. Sometimes it's not thorough enough. So it's really hard to know. So if you follow what I'm doing, you'll be able to streamline your process and save yourself a lot of headache trying to figure out if you're actually looking at the right information and enough of the right information or too much of the right information in the process. So let's go here into the US patent classification, class numbers and titles. So I don't want to get too complicated or too detailed on this, but you can see that the classification numbers are listed down the left side here. Now we had two numbers from those two sample patents that we might want to look at. One was 211 and the other one was 280. So we'll just scroll down here to get to those numbers and see what those classifications really are about. Classification 211 is about supports and racks. That's probably pretty close to what we're doing with my invention for the tool storage device. 280 is land vehicles. As I suspected, the fact that the golf cart version of the tool storage has wheels on it, it's then classified as a land vehicle. That's not what we want because my implementation doesn't in any way have wheels or isn't used to travel across land. So we're going to go back up to 211. We're going to say that's probably our closest one. We're going to look and see what that says about its class. So what you'll see here is basically an outline format for the entire class that we're looking at of 211. I don't remember which ones they were. Let's go back and look and see which numbers we were looking at. 70.6. Let's look at that one first. So 70.1 special article support or rack made from sheet material. You know, that might be what I'm doing right there. I want to take that, and we could click on that and read a little bit more, but I want to take that and I'm going to put that into my log. And I paste that without the formatting just so I don't get all the funky formatting and stuff on it. But that's something, a classification that might be interesting to us to search more. So the other subclass was 65. Let's look at that one. Brush or brush-like. No, I don't think there's anything related to my tool storage device that's brush or brush-like. I'm not sure, so we could always click on that and see what it says. Article includes elongated portion, brush or brush-like. You can also click on the number. The number opens up some other things. You can start to get lost in here, so I'd be very careful going too deep. This looks like it's for the types of tools, not for the storage device itself. So I'm going to skip that one. The last one was 87.01. These are specially mounted devices. Wall or window mounted devices. Yeah, that's probably what we're doing. I'm going to look down here and just see they've also got shelf and adjustable. So that might be something of interest. Anything else? A pivoted support. Vertical and horizontal axis. That might be exactly what I'm doing. So I might want to look at those. Foldable. Mine could be foldable. I want to be careful though, because I don't know if I'm looking right now at tools or if I'm looking at tool storage devices. And you can see these are just, we're in the miscellaneous category for supports and racks. So it's not the tools themselves. It's going to be the supports and racks that are pivotable or extendable or foldable. So this gives me an idea of a couple of the other classifications that I can search for my invention. Now that I have a couple of these classifications listed on my search log, I'm going to go back and I'm going to perform some additional searches using these classifications and excluding some of the more specific terms that I had in my other search terms before. Now that we're back at the search page, I'm going to use the classification number to do the search instead of using the keywords that we used before. In order to do this search, I want you to notice that there are different types of classification systems that you can search. The CCL refers to the current U.S. classification. CPC is the current CPC classification. CPCL is the current CPC classification class. ICL is the international classification. So you should know that those exist. When you're going back to the patent application that we looked at, we were looking at the current U.S. class. And if we go back to the classification index that we were searching through, if we go back to the beginning, we'll actually see that we were looking at the U.S. classification system. So that tells us that when we do our search, we want to be searching the current U.S. classification. So now, if we want to search that classification by itself without any other search terms, we'll just put in that we're searching the U.S. classification. We'll put in the class, which was 211, and we'll put in the subclass that we found, which is 104. I now have some additional search results that I could go through and see if I can find anything. A lot of these look like drying devices somehow. Device for supporting a bicycle, that might be interesting. So I'm going to go back and do one more refined search there. Now I know I'm in the classification searching storage racks that are foldable and that have the word tool somewhere in the abstract. These could be my very best references. So this reference, this is interesting. It's made to go onto a wall, or it looks like actually a pegboard. So then you can fold it into this triangular configuration here. It probably snaps together, and then hang it on your pegboard and store your screwdrivers in it. This isn't exactly what I'm talking about because it's not hinged in the same way that mine is hinged, but it gives me more information about the types of things that the patent office will look for, and a patent examiner would certainly, if given the opportunity, use something like this to say, no, that's a hinged tool storage device. It's close enough to what you're doing because your claims, if I don't write them the right way, your claims aren't going to show me that your hinge works differently than the hinges that are built into this panel when it's manufactured. So I now have a 16-page search report or log to show the searches that I did in both the patent database and the patent application database. This is what I can use to come back to later to see what I've done. If I need to reference something again, I can understand why I looked at things, either keywords or perhaps the classifications themselves. And everything that I highlighted in red is really visible to show that it's something I thought was important. Now you might do something where you highlight prior art in red. Sometimes you'll find really close prior art. I don't feel like I found really close prior art in the half an hour or so that I've been searching so far. But if I did, I might want to highlight that one color. And then other things I found were more informative to me as I want to go ahead and write my patent application to say maybe I should cover these other variants, or maybe that would make sense for me to work into mine too. And I might put that in a different color. My log can be used to both show me what's relevant prior art potentially and give me some information as to how I might modify or enhance my own patent application. Now keep in mind though, as you put other things into your patent application that you've drawn from prior art references, that's going to, at least with reference to the information that you've pulled in or the modifications that you've made based on that new information, potentially put you closer to the prior art, which might impact the ability to get it examined and successfully distinguish over the prior art that you've also kind of copied concepts from. So keep in mind that it's a good way to inform yourself and maybe think more broadly about your invention, but you don't want to outright copy things that will then cause you to not be able to get a patent because you copied them. That's it. You should now be able to use various techniques to perform simple and detailed patent searching on the U.S. Patent and Trademark Office website. I want to caution here that this is an area that I would consider to be a black hole for the patent process. You can spend hours and hours searching and looking for information that might be relevant to your patent application. Let's refer back to this graph that I'm showing on the screen. If your technical expertise is not extremely high, if your market expertise is not extremely high, chances are your time is best spent right now doing a very brief search, looking for knockout data and knockout prior art and nothing more. I would not spend more than 30 to 45 minutes, maybe 60 if it's your first time doing it, and just see what you can find in that time using these simple techniques. I wouldn't go into greater detail than that because you'll find that the amount of time spent isn't worth your while, especially when you've still got technical validation and market validation to do on your invention to determine whether or not you have a business that you can pursue to support this invention. It's also worth noting that there are other sources that you could search to come up with similar information. You could go to the Google Patents website, and if you just type in google.com/patents, you'll get there. You can search that database too in different ways. You can also use field searching like we've done here, and you might find that you like that interface better. There are also some more sophisticated and comprehensive patents databases that you can search. Those can also be useful, but they're harder to get to. And I think that you'll find plenty of information about the prior art that you need to locate just within either the U.S. Patent and Trademark Office databases or within Google's databases. You can also note, just as a final comment, that there are other databases that you can search for foreign references. There's no reason that foreign references can't be prior art to your invention. Now, in the past, there have been some rules about whether or not a reference needs to be in English in order to be a prior art reference. in the United States, I wouldn't worry about that. That's probably beyond the scope of the point you're at now, trying to get a provisional patent application filed. So I would not worry too much about foreign references unless you happen to know about them yourself. Once you know that a reference exists, we can't just pretend that it doesn't, because you have a duty. It's called a duty of candor with the patent office. In fact, you have it. Anyone else involved in your business around the invention would have it. Any patent attorney that you hire would have the same duty. And that duty of candor just means that you are going to inform the patent office of any references, any prior materials that the patent office might think would be material to examining your patent application in the future. Now, you don't have to do that at this stage with the provisional patent application. It's not required to disclose anything to them about the prior art you've found. At this stage, it's just about keeping records, making your own provisional patent application better based on the information you found by avoiding prior art or by incorporating some additional variants into your application. And then keeping a log so that in a year or so from now, when you file a non-provisional patent application based on the provisional, you'll be able to fulfill that duty of candor at that point in time. And I need to make one final comment, and I think this might be the last one for this section. When you go through this process, hopefully you come out of the process more confident that you've found your invention to be novel, that it's not out there, made by anybody else, described by anybody else. You can't find information about it. You can find information related to the technology generally, perhaps, but hopefully can't find anything specific to your invention. That would be ideal, because that would mean that you have more confidence that yours will be unique and novel and patentable. However, you might find after going through this process, even after a few minutes of the process sometimes, that you come across something that is strikingly identical to what you thought was brand new in the market. That's never very fun, because we don't like finding out that where we thought we were going isn't actually where we're going to go. However, I think there is a silver lining to the possibility that what you have invented might be out there already, invented by somebody else, or might be described by somebody else and isn't patentable by you. What that can do in that situation is allow us to go ahead and recognize that what we thought was a good idea for an invention or for a business is not going to be the basis of a business for us this time around. Now, you could still go off and you could create a business around that if it's not going to infringe somebody else's patent. But most of the time, inventors like inventing a lot more than they like the business. And in order to get excited about building a business, they want to be sure that their invention is novel and new and isn't like something else that's already out there. So when you do run into something that is like what you're trying to invent, you should take the opportunity to say to yourself, I went ahead, I've tried to do this, and part of this process, part of being able to use the provisional patent application process and this efficient searching mechanism is that you get to filter through a lot more inventions than you would otherwise be able to do if you were paying somebody $1,000 or $2,000 or $4,000 every time you wanted to get patent information or a patent search done about your inventions. So you're fortunate now that you get to be able to process your inventions more quickly and more efficiently. You'll find that you will be filtering through a lot of them faster than you could have done otherwise. That means, of course, that you'll be filtering out some of your inventions that aren't viable or that don't form the basis for a good business. And that's okay, because as an inventor, I'm sure you've got lots of inventions, and you'll be using this process to find and pursue only the very best ones.